Welcome to the Legal Advice in Paradise podcast, brought to you by www.legaladviceinparadise.com. Even in one of the most beautiful places in the world, life can be litigious. On this podcast, the best and brightest legal minds gather to help you navigate your way through every legal question you may face. This program will help you know your rights, know what steps to take, and help you find the best legal representation, all in simple, easy to understand terms. And now, here's your host, Justine Gronwald.
Aloha, Agents of Change. This is Justine again at Legal Advice in Paradise. And today it's my honor and privilege to have Mr. Bob, you go by Bob?
Yes.
Kessner, of his own firm. And we will be covering today workman's compensation. So to open up, just tell us a little bit about yourself.
I'm Bob Kessner. I'm the founding partner of Kessner, Umebayashi, Bain, and Matsunaga. I've been licensed to practice in Honolulu since 1973, and since 1977 I've concentrated my practice in the field of workers' compensation. You need to understand I represent employers and injured workers, so I come from that side of the issue. However, I think I can speak with some authority to workers' compensation in general, the basics of the system, and how it works here in Hawaii.
Okay, perfect. And I think we're going to start at the very basic. I think the general public have an idea what workman's compensation is, but until you experience it or go through it, there's more details to it than the basic knowledge, right?
Yes.
Okay, so exactly what it is and who provides it and who's affected.
Workers' compensation is what we call a creature of statute. It is created by law by the legislatures in each of the different 50 states. The workers' compensation law will vary from state to state, so depending on where you are, you want to make sure that if you go to an attorney, you go to one who's knowledgeable in that particular state. Mm-hmm. Workers' compensation addresses injuries which have a connection to work. So by definition, you have to have an employee and you have to have an employer. Employers in the state of Hawaii are mandated by law to carry workers' compensation insurance coverage. There is a list of qualified insurance carriers, and the employer can go to any of those to purchase their coverage. They also can qualify if they are rather substantial employer financially as a self-insured. But the bottom line is most of this is done through insurance companies, which means we really have three players in the system. We have the employer, mm-hmm. we have the worker who's gotten hurt, and we have the insurance company that's providing the coverage. The requirement that there be a connection to work, the term of art is there must be a nexus between the fact of the injury and the fact of the work. Simply because something occurs during work hours does not necessarily mean it is covered by workers' compensation. Conversely, the fact that something happens outside of work hours does not mean that it's automatically excluded from workers' compensation. There needs to be a causal link between the fact of the work done by the injured worker and the fact of the injury. Mm. Once the injured worker is hurt, the most important thing to do is to immediately report it to a supervisor or to a manager. There is an obligation that notice of the injury be given. If the claim is notified and it is accepted, as is the majority of the cases, and in this regard I would say I see perhaps 5% of the cases that happen. I only see cases where someone has tried to overreach and claim more benefits than is due them, where there are multiple issues of causation, where there are problems as to which employer when you have an exposure to disease type of situation. So I don't see the typical run-of-the-mill case. In the majority of cases, the worker will tell their supervisor, I fell in the back room and I think I've injured my back. Mm-hmm. The supervisor may say, why don't you take off and go to your doctor? It's important to tell your doctor that this was a work injury because workers' compensation has a very regulated medical system. Once you are injured, the employer in the meantime will have contacted the insurance company. The insurance company will likely have someone call the injured worker, interview them, and find out what happened. The employee, the injured worker, has the right to select any doctor they want as long as it meets the definition of a medical care provider, which is set forth in the workers' compensation law. In Hawaii, that's Chapter 386 of Hawaii Revised Statutes. So the basic benefits you can get are your medical care. You need to get better so you can get back to work. There is a thing called temporary total disability. You're likely going to miss time from work if you've had a bad back injury. Temporary total disability is the wage loss component of the system. This entails looking at your average weekly wage and then providing you a benefit that is equal to 2/3 of what that average weekly wage was. Actually, by our statute, it's 0.6667.
Wow.
There is a maximum you can get in any given year. Currently, it's $777. When I started doing workers' comp, to give you an idea how long I've been around, the maximum you could get was $112.50.
Wow.
Each year, that number, the maximum weekly benefit rate, is readjusted by the Department of Labor based upon the wages being paid in the state during the prior year. So each year it tends to go up. There was one year, I believe it was 2011, 2012, when the recession was hitting here, when the average weekly wage actually went down, and accordingly the maximum benefit rate went down. So you've got this injured worker who's timely reported their accident, they're off work, they're getting temporary total disability at what we'll call 2/3 of their average weekly wage. They're getting their medical care. Several months down the line, the doctor says, I think you're ready to go back to work. However, you're going to have to watch it. You've got some permanent problems. At this point, the injured worker will likely be sent for an independent medical evaluation with a permanent impairment rating. The way the law addresses the permanent aspect of an injury is through what we call permanent partial disability. Permanent partial disability is based upon permanent impairment as rated by a physician under the American Medical Association guidelines to the evaluation of permanent impairment. Currently we're using the 5th edition here in Hawaii. There is a 6th edition, but we've not adapted that as yet. This will allow the doctor in Hawaii to reach a similar conclusion to the doctor rating the same person in California, rating the same individual in Florida, rating the same individual in whatever state they may happen to live. It's an attempt to standardize permanent impairment. Typically with a back injury, we will see people in a category 2 if they have some permanent complaints, and they will be given an impairment rating of between 5 and 8%. That then is translated by the director or through the negotiated process, and commonly workers' compensation claims are resolved through negotiation. The doctor rated 5%. Can you give me 6%? Can you give me 7%?
So there's a negotiation?
There's absolutely negotiation. I negotiate easily 90% of the cases that come before me. At the end of the day, they resolve through a negotiated settlement rather than through the process of litigation. The system moves very slowly. If you are injured today, the 15th of July, 2014, it is not unlikely that you would not get to go to a hearing until December of 2014, or perhaps even into 2015. Once you go to a hearing, the Department of Labor has 60 days to render a decision. Once a decision is rendered, you have 20 days for the dissatisfied party to file an appeal. Should an appeal be filed, it goes to the Labor and Industrial Relations Appeals Board. The Appeals Board then holds what they call a trial de novo. That is to say, we go back to square one and it is a whole new trial.
Wow.
That trial may not be scheduled for a year after the appeal is filed. The decision may not be rendered for a year after the appeal is heard at trial. So you can add 2 years or more with the appeals board process.
So let me ask you this. What's happening in the interim I'm taking it that this person is not able to perform as usual on the job. Are they still receiving the 2/3, or how
As
is that
long
working?
as there is medical certification that the person remains totally disabled, they have a theoretical right to be on TTD. The employer may disagree. The employer may say, wait a minute, I've heard from your coworker that they saw you working elsewhere.
That, I hear stories like that where people are collecting this and then they're doing activities that normally what they're claiming they can't do, doing it in some other way, be it a hobby or some other things.
Well, let's look to the good guy first.
Okay.
The good guy, who can no longer do his usual job, has a benefit called vocational rehabilitation. You are allowed to choose one of the certified vocational rehabilitation counselors that the Department of Labor lists. That person will work with you to determine what are your best transferable skills. Should you be directly placed into a new job? Should you be given training to move into a different field? Should it be computer training? The most extreme is you might have to go to a couple of years of community college. During the time that you are enrolled in vocational rehabilitation, you are receiving the temporary total disability benefit. So that's the good guy.
Yeah, that sounds like a good program.
Now, let's talk about the person who's taking advantage, the one who's actually working elsewhere. They have to be concerned with the fact that our law provides a fraud section of the statute. If a person makes a misrepresentation or fails to divulge information pertinent to their claim, they can have a complaint for misrepresentations filed against them. This cuts both ways. If the employer has misrepresented to the injured worker, there can be a fraud complaint brought against the employer. More commonly, we see fraud complaints filed by employers and insurance carriers against employees who are attempting to overreach. They're claiming benefits that are not appropriately due them. They are telling us that they're totally disabled, when in fact the private investigator has film of them participating in the local Tin Man.
Oh, can I ask you a question?
Sure.
So the employer, the company, actually hires a private investigator?
Yes.
Okay, so it's on the burden of the employer to...
In order to prevail on a complaint for fraud, you have to bring evidence that there has been a misrepresentation made to someone in order to obtain benefits. That may be lying to your doctor. That may be telling your doctor, I can't lift more than 5 pounds, so I can't go back and do my job as a construction worker. When in fact the private investigator has film of you doing construction type activities. There you've made a misrepresentation to your doctor. You have failed to tell the employer about this outside work. And in that instance, if you're found out, likely a fraud complaint will be brought. If a fraud complaint is brought, for each count of fraud that the director finds, there can be assessed a monetary fine of up to $10,000 per count. We recently had a case where the injured worker was found to have committed fraud, and the monetary fine assessed by the director was $90,000.
Dang.
In addition to the monetary fine, the worker who has been found to have engaged in fraudulent behavior can have their right to workers' compensation completely terminated. That's it, your case is over. They can be ordered to reimburse medical care that they received after the first date a fraudulent act was found to have been committed. They can be ordered to reimburse temporary total disability benefits that they've received. And they can be ordered to pay the attorney's fees of the employer and insurance company in pursuing the fraud. So basically, it's important to be honest.
Yeah.
It's like
Yeah.
any other system. If people are honest, if they behave with integrity, then I don't have a job. I'm out of work and I can retire, and that would be wonderful. But the fact is, there are people who still feel they're entitled to more than they really should get, and they will misrepresent their situation in order to get that. and that's when a fraud complaint comes in. But that is not really common. I would say no more than 1 out of 50 cases that I see truly warrants a fraud complaint. And remember, I'm only seeing 5% of the cases. The other 95 get resolved between the injured worker directly working with an insurance adjuster, or the injured worker and his attorney, his or her attorney, working with the insurance adjuster. I'll only get the case if it becomes very problematic or there's a huge amount of money involved. There is no limit to the dollar amount that workers' compensation can pay. We recently settled a claim where the total payout was close to $750,000.
Wow.
So there is, now this person is totally disabled, not that old, and is going to require substantial medical care for the rest of their life. And part of that medical care is going to be pretty expensive medications. You have to be aware that there is an overlap. There is, especially with an aging workforce,
Yeah.
as people become more advanced in their years, they get closer to the date that they qualify for Medicare. And we already have a lot of people in the workforce who are Medicare eligible.
Right.
Medicare says we're a secondary payer. We don't pay if workers' comp should. Once the Medicare system gets involved, in order to settle a case, it is necessary to go through a number of hoops that this is probably too advanced for this discussion, but there are things called Medicare set-asides and needing for approval from the Center for Medicaid and Medicare Services. So it becomes a very complex
Yeah.
little animal.
Well, you know what? I'm glad you brought that up because, I've sat with attorney Scott Makuakani, and we talk about elder law, estate planning. And as I'm doing this interview, I'm really seeing the numbers of people advancing in age, and they're going to be around. The aging population is going to explode, and I'm guessing that affects the workforce. More of them will be working longer than the 65 years that most people used to, or do early retirement at 62.
Absolutely the case. And
yeah.
you also find with an aging population, there are infirmities that come to the human body with aging.
Right. That's natural.
And so your aged worker is more likely to be injured lifting the heavy object than your 25-year-old fit worker who goes to the gym every day. So we see problems of that nature. If you have someone who's had an injury already and has been permanently impaired because of it, the employer interviewing that person for a new job might say, I'm skeptical about hiring this person. They've already got an impairment. The law seeks to take away that adverse impact by providing a special compensation fund.
Oh.
If you are injured on the job and the results of your injury combined with a pre-existing impairment cause you greater disability than you would have had from the industrial accident alone, the employer has, upon meeting certain criteria, the ability to call the state special compensation fund in. This spreads the load out. The special compensation fund essentially is a repository of monies paid by all insurance carriers and self-insured employers based on their volume of business. And it sort of spreads the risk. And it also means that the guy who had the pre-existing disability doesn't face prejudice when he's interviewing for a job.
I was going to say about the discrimination and everything. That's a fine line, though, and I can see both sides of it. As I mentioned, the aging population still needs to work, especially someplace like Hawaii. And at the same time, the companies need to watch their costs. I imagine, insurance premiums and everything come into play, and this sounds like it's an extra rider to the insurance.
It is, and it is a factor that is considered when it comes time to negotiate settlements. Most insurance carriers prefer full settlements. Workers' comp normally continues your medical care even after you've gotten your award of permanent disability. If you need to go back to the doctor for a checkup, that's part of the system. Most carriers, when they're paying a substantial sum of money for a settlement, they insist that they be able to close the case fully, which means the injured worker will waive their future medical care. They will waive the right to reopen the claim in the future to say, hey, there's been a change in my condition. I'm worse now than I was when we settled up my permanent disability. I think I'm entitled to a greater amount of permanent disability. Let's litigate all over again. Most employers, and they are not obligated to pay lump sum settlements. If we are unable to reach an agreement and the case goes before the Director of Labor, a hearings officer will hear the facts, will render a decision. The award of permanent disability that is in a decision is payable in biweekly increments. That weekly benefit rate, whatever year it is, the maximum weekly benefit rate is applied against a schedule. The schedule is derived from the experience of many states, but it will say, for example, that the arm is worth 312 weeks, whereas the leg is only worth
The body
288
parts have
weeks.
value to it.
Whereas the hand is worth 244 weeks.
Wow.
But your heart condition is worth 312 weeks, as is your low back and your neck.
Wow.
We take the number of weeks set forth in the schedule, multiply it by the maximum weekly benefit rate for the year of the injury, and we multiply that product by the percentage of disability that's been awarded. So that's how you get your number for permanent disability.
So it all depends on the body part, and that's all taken into consideration.
Yes.
Well, that's great. You know, before we close, we're going to do a sponsor recognition.
Sure.
So we'll be right back.
Okay.
Okay, we're back. Thank you for joining us again. We're going to end now, but like in many of my interviews, I do ask the legal experts about finding the right attorney, and this is for workers' comp. So what are your feelings about finding the right attorney?
Well, as I said at the outset, I represent employers. But if you're an injured worker, it is important that you have an attorney who knows the workers' compensation system, who's got experience in the system. There are a lot of pitfalls for the practitioner who's not familiar with it. The best place is to call the Labor and Industrial Relations Appeals Board. They have a listing of attorneys, in fact, it may be on their website, who they know are competent to practice workers' compensation. If you're interviewing someone and you don't have those resources, I think I would ask them, how many workers' compensation claims have you handled before? If you're not getting an answer of, I've had 100, I've had 500,
Ooh, that many, huh?
then you should probably look to a different attorney. The guys that I consider very responsible in their work on behalf of the injured worker have literally handled thousands of these cases. They know the system well. They are efficient in the way they do things. And that's important because the injured worker pays his own attorney's fees. They are not allowed to pay directly. It must be approved by the Department of Labor. If you're an injured worker and you're seeking counsel and you go to an attorney and he says, well, I'm going to need $1,000 before I can talk with you, I need a retainer, you've got the wrong attorney.
Oh, really?
Because the law says that an attorney cannot take a fee for workers' compensation representation
Wow, that's good to
unless
know.
it's approved by the Director of Labor.
Wow.
If your attorney has asked you to pay beyond what the Director of Labor approved for the attorney's services, you have a problem with that attorney, and you should probably speak with the Bar Association.
Wow, that's some really, really good tips, because that's the purpose of this show. So I'm glad you brought that up, is that a lot of us we don't have any legal knowledge whatsoever, zilch. And, you know, if you get injured or whatever happens to you and you need legal counsel, I think a lot of people just jump into finding whoever they can, and the attorney feels that he can handle it when both of them are on to a really bad, ugly journey. That's all I can say, because it's kind of like what happened to me. And
For the experienced practitioner, the regulations are not difficult to navigate. For the inexperienced practitioner, there are pitfalls that will cost the injured worker at the end of the day.
Well, I thank you so much for that information, and thank you for your time.
Thank you.
And usually what we do on the video, we shaka out, we say shaka. And on the audio, we say aloha and ahui ho. Until next time.
Thank you for listening to the Legal Advice in Paradise podcast. For more information, visit www.legaladviceinparadise.com.